Give me just a moment or two to get my computer open. Oh, no, because you can't remain standing then. We'll go ahead and call the case. This is the time set for a return in CD 2016-002, 889 John Brakey versus Michelle Reagan et al. Counsel, why don't you go ahead and state your appearances.
Good morning, Judge Michael Pilsky, appearing on behalf of the plaintiff.
Good morning.
Good morning, Your Honor. Colleen Connor, Deputy County Attorney with the Maricopa County Attorney's Office. I'm here with Edward France, and we are representing the Maricopa County defendants as well as Pima County defendants.
Thank you.
Your Honor, Jim Driscoll McCaffrey and Tara Carlson on behalf of the Secretary of State Michelle Reagan. We're also making a limited appearance today on behalf of Attorney General Mark Brnovich, who was served yesterday in this matter.
All right. Other folks? Anybody making an appearance?
Tom Sox, I'm making a limited appearance on behalf of County.
Chris Keller making a limited appearance on behalf of Carroll County.
All right. And I know I have Coconino County filed a motion. Is anybody here on the behalf? I'm just making sure. Don't see anybody. All right. Just to start, and yesterday I did have a brief telephonic conference that was on the record with counsel, just to make sure that we had, I'm sorry, but unless you have been given express permission by the Media Relations Group, you are not permitted to record these proceedings. There is a recording that you can order. It's available, but I'm going to ask you to please turn off your cell phones and things like that. We do have, it is being recorded, audio and visual. It is available, and folks are welcome. I think my bailiff gave the phone number at the end of the hearing. We'll give the number again so that you can get it. All right. I had a brief discussion. One, we did resolve that the Secretary of State did not need to bring ballots or contested ballots, and frankly we can discuss what may be contested here a little bit today. And we also talked about a few other things. Give me a moment so I can see what my JA needs. Unless you want to walk over and see if they can turn it on with the conditions quickly. Or is that see if somebody else has to report. Sure. And what I'm trying to do is see if there's a courtroom that folks could observe this through what's called the FTR system. But and please, I cannot answer questions. I just can't do that. I'm trying to see if another courtroom is available where if you watched on a video screen.
May we sit up here, sir?
No. And I'm sorry, but nobody is going to sit in the jury box. And I advised counsel of that yesterday. The jury box is a very unique place, and it is not a place that I allow anyone to sit other than jurors. All right. We talked also about folks that I know and people that I have met over the years and what I have done before. And I make this disclosure so that nobody says, gee, I wish I would have known that. But not because it creates any kind of actual conflict or would cause me to recuse myself. I have looked at this carefully. I certainly feel quite capable of being fair and impartial in this case. But I will go through these disclosures on the record. I worked on election laws and helped draft some of them, not the ones that are presently before us that I am aware of. The ones that we're talking about existed a long time ago. As I worked at the Arizona House of Representatives for the better part of a decade as counsel to the Democratic caucus there. I left the House of Representatives in 2007. I did meet Michelle Reagan then. She was a representative, and then I believe she was a senator. I also worked with Maricopa County Supervisor Steve Gallardo and other elected officials. So I've known people for quite some time. I also met with members in Karen Osborne and Helen Purcell in that capacity and other election officials around the state. I actually appeared and represented Secretary of State, then Secretary of State Jan Brewer, in petition challenges. In that regard, I was at the Attorney General's office. The Secretary of State is a nominal party in those, basically just appearing because it impacts the printing of ballots and things like that. So I did make appearances. The last time I did that was on 2008 primary election petition challenges. I've known the Secretary, I know her. I don't know that she would be able to tell you my name. She probably would recognize my face, is probably where we're at. I will also say I know her elections director, who I know is here in the courtroom. I don't say that I know him well. We worked on town hall together on what's called arts and culture. I was the panel chair, and he was one of the recorders for that. I have worked as a troubleshooter for Maricopa County. The last time was in 2008 for the presidential election. Troubleshooter is a person who is very similar to a poll worker. It's just I would have had 5 or 6 polls that I was responsible for helping maintain. They were all in South Phoenix, or Levine, and the Gila Indian Reservation. The last time I did that was the presidential election in 2008. It was just a temporary job that I would do a few days before the election through the election day. And yes, I did actually take poll workers home at the end of the day because they could not drive after dark. In 2008, I was a pledged delegate to the Democratic National Convention on behalf of Barack Obama. It was at the congressional level. My spouse and I have given money to campaigns in the past. I haven't given any this election cycle. My spouse has. From memory and from double-checking the FEC website, my spouse did not contribute to any of the candidates on the presidential preference primary. So none of them, and from my review at any time in the past either. I was this Friday to present on the CLE on a panel that involves the presiding civil judge Randy Warner, Karen Osborne, Helen Purcell, and the Assistant Attorney General in this case, James Driscoll McCackern. I have met with Judge Warner, Ms. Osborne, and Ms. Purcell to prepare for that. In that regard, we prepared the materials, and it is on petition challenges. That's all we're talking about, not what we're talking about here today. I have never, to my knowledge, met Mr. McCackern before, perhaps in passing, but not in any significant way, and we didn't work together. He prepared materials. I am not going to participate in that because of my role in this case, but it is unrelated. And again, the last time that I had contact with them was regarding the handouts, and it was before this matter was filed, with the exception of just passing them on the street and saying hello. I did work with the presiding judge, Karen Osborne and Helen Purcell, on the process for petition challenges this year, just to make sure that we move them through. I am friends with folks on Facebook, including Ms. Purcell, Secretary Reagan, and 807 other of my closest friends and family, and I think the folks understand what Facebook friends are. Some of them work at the Secretary of State's office, the Attorney General's office, the County Attorney's office, County Recorder's office, etc. Mr. Kielski and I are not friends. I am friends with also Eric Spencer, who is the elections director for Secretary Reagan, though again, my relationship with him was at the town hall event. Mr. Kielski and I are not friends. We have 25 mutual friends in common, and Mr. Kielski, one of them happens to be Secretary of State Reagan. So from my perspective, I don't have a conflict, but I am with folks walking out of here saying, gee, I Googled him, I looked this up, and I found it out later. I don't see any problem. I am, as I told the attorneys, happy to rule against anybody that is in this case, or rule in favor of them, depending on what I have before me. So with that, longer disclosure than I think had any obligation to make, but I understand that you folks are also very focused on making sure that you understand everything. So I've done that. Is there any concern on the part of any of the council? I'll start with plaintiffs.
None, Judge.
No, Your Honor.
Anyone else? I'm getting a no. So we're going to go ahead and go forward. Trying to move the scheduling along and figure out what to do. I have several motions to dismiss, one filed by the Secretary of State's office through the Attorney General. I have one filed by, I believe, Pima County, Maricopa County, Yavapai County, Coconino County, joined in Yavapai County. I believe Pinal County has filed one, but I don't have a copy of it. Am I correct?
Your Honor, you're correct. We filed a notice of limited appearance and joined her Maricopa County's motion to dismiss.
I knew that there was something, but I don't have a copy of that. I don't know that any of the other counties have appeared. Did I miss anyone? Don't think so. And I know that 12B, Service, the Diaz case, raise an issue. And yeah, I asked you folks to talk about briefing schedules and how long you folks were going to take to put things together. I'm familiar with what the issues are. So did you folks have a chance to talk about how we're going to deal with those specific motions? I don't know who wants to go first.
Judge, if I may just very briefly address a couple of the underlying fundamental issues that were raised in the multitude of pleadings that have been filed by the other parties, limited scope or otherwise. One of the issues that were raised was service. Judge, we spent the better part of last week asking for waiver of service from the Arizona Attorney General's office on behalf of the state defendants, and we were unable to obtain that, so we procured personal service yesterday, and we will be asking the court pursuant to rule.
Is that on the governor and the attorney general?
And the governor, attorney general, and the secretary of state, because we could not get them to agree to a waiver, and therefore we will be asking procedurally pursuant to Rule 4 to have the court order them pay the costs of that service as well as the costs for the application for applying for those costs.
What about the counties?
I'm sorry?
What about the counties?
Well, I believe that there's a statute. The statute provides that the counties are necessary defendants because they have been delegated the authority by the Secretary of State. And to the extent that the Secretary of State has been served, because the Secretary of State is the authority and the counties are merely the delegates, I believe the counties therefore don't have to be each individually served. Judge, but if the court feels that...
Do you have a statute that I can rely on for that? I know there's a statute that deals with the election challenges.
Right, Judge. And so we'll if we start by 6, I believe it's 6. So I got that.
And we don't need to argue right now. Did you talk to them about the briefing schedule on it? I'm trying to...
We've talked about briefly about the briefing schedule. Again, the state defendants want the briefing schedule. Want me to have a response very, very quickly, Judge. I'm asking for a little bit, and a few more days. But again, I'm willing to do whatever we need to do to move this case along because we need to get this. We need to get this pursuant to the time limits that are inherent in the statute. We need to get this set to an evidentiary hearing as soon as possible, if one is to be had. So, Judge, I'm willing to, as far as those issues are concerned, I'm willing to do whatever is required. I was asking and suggesting that we have an opportunity, because of so many individual pleadings were submitted, that number one, we be allowed until Friday to respond to all those motions, and that we be allowed to respond in one pleading rather than having to create a separate pleading for everyone. Judge, again, I mean, you can look at the slightly unbalanced courtroom. I've got a lot of people that are interested in this behind the bar, but on this side of the bar, there's me, and then over here we've got half a dozen or more individuals. So, Judge, again, I'm the one doing this.
It seems to me that most of the counties are pretty much raising the same issue,
and
except
that's
for Maricopa.
Right.
Maricopa may be having a little bit slightly different.
And again, that's why, Judge, I would ask that the court give me a reasonable amount of time to respond to each of the points, and if the court would allow me to respond in one pleading rather than having to file, I believe my count now is 5 or 6 different responses.
And I don't have a problem with the one pleading as long as you specifically identify this as Yavapai, the ones that raise it and address it that way. I'm fine with that. My concern is the timing. And I'll just review the statute as far as the timing, because this is where I see the challenge. By scheduling the hearing for today, in a lot of ways, you were given the maximum amount of time to serve folks, because the hearing has to happen by today, or for good cause, I can extend it by 5 days. The challenge is 5 days from today, because you can't count today, is Wednesday, Thursday, Friday, Saturday, Sunday. They can't hold a hearing on Sunday. So the longest I could extend it would be through Friday. The hearing has to start by Friday under the statute. And what I'm hearing is the Secretary of State and the state defendants, I thought there was a notice of service of some sort filed before. Maybe it was a different notice, but they weren't actually served until yesterday.
Well, again, Judge, this is the issue that they raised, that the state defendants raised with us. On the day that we submitted the original pleadings in the Superior Court here, I went down to the Executive Tower and we delivered a copy of that. And we were receiving some pushback from that, saying, well, you can't serve. You're a party. You're an attorney for a party. You can't deliver these documents since they have to be personally served. We were trying to get a waiver of service, and they were saying, well, no, we're not a proper party, so we're not going to waive service. So as I said, we procured personal service yesterday at an additional cost to the plaintiff. As far as the county defendants, again, if the court believes, and in the abundance of precaution, that personal service is necessary, we'll get personal service done today, Judge. That's not an issue. It's going to be a significant expense. And again, because we've asked, I would argue because we've asked the state defendants for a waiver by way of the Secretary of State, and they have refused, then we would ask that those costs can be shifted on to the state defendants. Or I can ask the individual representing the various counties here present today if they're willing to, on the record, waive service for today's purposes. Again, pursuant to Rule 4, the requirement to save costs.
Let me ask you this: if service had to be done and it was not done timely for the counties, what happens? Can I go forward?
Well, I don't see why not, because even if one or more of the counties is dismissed, not relevant to the issue, which is the issue is, and Judge, if you go back to our complaint is saying the Secretary of State certified this election. The certification should be voided because this election was largely the results of the election were provably not correct. The conduct of the election, again, right from our complaint, there was miscounting, there were illegal votes, and there was an overall denial of the misconduct of the election itself. So, Judge, again, the heart of the issue is we've asked this court, we've asked you, Your Honor, to order that the Secretary of State void her certification of this election.
So let's say I do that, and the counties aren't parties. What happens?
That's it. Then at that point, if the state parties want to go to some alternative means of determining what the outcome would have been, as long as they comply with state law, they can do that. If they want to conduct another election, they can do that. It's all up to them at that point.
Okay.
But the issue is the Secretary of State as the chief elections officer. The Secretary of State has gone and said, well, I'm getting all this information from these 15 counties, and they're telling me this, and I'm going to go ahead and put my rubber stamp on it. And we're saying, no, based on the evidence that we're going to be able to present, you couldn't have done that. You knew, you should have known that this election was not a proper election, was not conducted according to Arizona law.
But all I can do is void it. I mean, I don't order a new election at that point. I don't have the
I don't think there's authority for this court to order a new election, but there's
I don't
certainly
think there is
authority.
either. That's why I'm asking it.
That's why we didn't ask for that.
Okay.
And again, we're just looking at what the power of this court is. In an election contest, the court can look at the contest and say, well, wait a second, this was not a proper contest. And in this case, because of the unique category of election that the presidential preference election was, there isn't a winner that's declared, there's simply a result that's declared. And all we're saying is we're asking, pursuant to the statutes, Judge, you have to order the Secretary of State to void her determination that the results are valid results.
Let me ask you this, because this is the next step then is is anybody, the parties use that information, and that's who uses that information. They
Sure.
use it, I think there are 3 parties that were involved. And was it the Democrat, Republican, Green Party? Or
I believe that's correct, Judge.
I think the Green Party. But no one else does. So does voiding the election have any consequence to them at all? Do they just follow it, not follow it? I mean, they can do that anyway.
Absolutely. It's, at that point, it's up to them, and it's up to their own internal documents. Again, that's the bizarre world we find ourselves in, is that the Arizona Secretary of State has certified the conduct, has certified the results from this election. The purpose of that election was for internal party matters. And again, Judge, I'll tell you from personal knowledge, that's why the Libertarian Party repeatedly does not participate in this, because that's an internal matter for a party that should not be, the state should not be required to bear that burden. But nonetheless, that's not an issue here. The issue is, if the state has taken that responsibility, it is still required then at that point to conduct its elections according to the statutes, and that's what didn't happen.
Okay, let me go ahead and probably start with Secretary of State, because I think at this point you're the one who's been served here in the room, and you're going to be the Attorney General.
Thank you.
And not you, but your client.
We're actually making a limited appearance on behalf of the Attorney General as well. I want to clear up a couple of errors in plaintiff's discussion of service.
Okay.
He is correct that the only manner in which he served the Secretary of State was by, first, the plaintiff, John Brakey, served several of the documents to the Secretary of State's office by himself. Then the plaintiff's attorney served the order to show cause later that same afternoon. The only discussions about a waiver of service involved whether or not the Attorney General's office, on behalf of the Attorney General's office, would waive service. Plaintiff is working under the theory that he thought it was appropriate to serve the Attorney General and the Governor under 16676A, which requires the Attorney General and the Governor to be served in the event of an election contest involving a proposition, referendum, constitutional amendment, or other question presented. We had discussions over the weekend and through the early part of this week. The Attorney General's office position is that we are not a party to this lawsuit, we have not been named in this lawsuit, and that it's not appropriate to name us because this is not a contest under 16676A, the other question presented provision. Ultimately, last week, we emailed plaintiff's attorney to inform him that because a waiver of service essentially would make us a party to this lawsuit, that the Attorney General could not even accept papers that would be purported to be a waiver of service. The next step that we heard was that yesterday morning after our conference call, the Attorney General's office received formal service as the Attorney General. To our knowledge, and I have the process server statement here, I'd be happy to show it to the court, it names the Attorney General as the party being served. The Attorney General, if I can just digress on that point momentarily, would like to file an oral motion to quash the summons and to file a motion to dismiss. We'd be happy to do a written one if that's easier for the court, but again, I have the summons here. The Attorney General is not a named party to this lawsuit, and the summons is not actually directed to the Attorney General. If you look at the language, and under Rule 4, the summons has to be directed, and it should be to a party. Neither of those conditions have been met here. We'd also argue that it's inappropriate to name the Attorney General for the reasons I gave before, which is this is not an election contest that is challenging the election in which proposition, referendum, constitutional amendment, or question has been declared carried. That is simply not the case that we have here. It's my understanding that the Secretary of State's office did receive formal service at some point yesterday. We're trying to confirm if that was actually in this election contest. I will take plaintiff's counsel at his word that he did formally serve that. We will verify that and let the court know. However, we have also been consistent in our communications to plaintiff's attorney that he did not serve the county defendants. We had a call last Tuesday in which we clearly communicated to him that there were issues with his service on the secretary, but the more profound issue was that his summons cited an authority of 16351D to allow him to serve the secretary and through the secretary serve the county defendants. 16351D applies only to nomination petition challenges. This is an election contest under an entirely separate statutory provision, and that statute provides no authority.
Can you remember again? I just want to pull it up so I'm looking at it.
It's much later, 16351D.
Okay, I just have to get there.
And you'll note in that section, it begins with purposes of nomination petition challenges. And again, this is not a nomination petition challenge. There's been no further communication with regard to serving the counties through the Secretary of State's office or any acknowledge, frankly, that the plaintiff was seeking for the secretary to waive service in her capacity since our conversations last week. The first information received about that was when the Attorney General's office received formal service yesterday, and it seems that perhaps the Secretary's office received formal service as well.
Okay. Let's just, for devil's advocate purposes, assume that Secretary, in fact, was given those documents by a person, served personally, but it was not by a process server, but got them that Friday. If the Secretary of State is the only person that's been timely served, what happens? He's saying all he's asking for me is to void her order saying these are the results of the election on a statewide basis, not anything else.
Your Honor, I think plaintiff is held to the allegations he makes in his complaint, and if you look at plaintiff's complaint, there are only 2 allegations that actually involve alleged violations by the Secretary. There's a general paragraph, I believe it's paragraph 24, that says as a result of the allegations also in the complaint that the certification should be voided. But there are only 2 places where, and the plaintiff is quite specific about who he alleges violated provisions, and throughout the complaint he refers to county defendants, or several of them. There's only in paragraph 17 and paragraph 19 that he actually alleges anything that the Secretary may have done incorrectly. And those are 2 very limited allegations. The first involves purportedly there was unauthorized access to the election results, and purportedly there was unauthorized access to the statewide voter registration database. The other allegations are not addressed to the Secretary. So if the plaintiff wants to prove out his case, his obligation is to prove out his case against the county defendants. They are necessary parties because he's challenging their conduct in the presidential preference election.
And the governor's office isn't here. I understand that they were served yesterday with the summons, but they're not a party, and so they're not here, as I understand it. Okay.
And I would emphasize, just for the record, as Your Honor knows, that the Secretary's role in certifying election results is a limited role. It is a largely ministerial function.
Do the counties have anything that they want to add right now? I'm truly trying to figure out, okay, where do we go from here, and how do we do this?
Your Honor, on behalf of Maricopa and Pima counties, we request the court set the response deadline of tomorrow at 5 o'clock. And in the election contest statute timeline, things are supposed to happen expeditiously. Mr. Kielski's been on notice about the motions to dismiss since last Friday. By and large, all of the motions make pretty much the same arguments with a few variations here and there. Also, in the context of what's going on, there is another statewide election with early voting starting tomorrow. And in the interest of the counties conducting the next election, having this election contest handled expeditiously is in their best interest. Thank you.
What about the deadlines that I'm facing? Because the statute says 10 days, can continue for 5 days. Well, historically, seems to have been recognized as 5 calendar days, and that puts it at Sunday. So, to do anything on that?
Yes, Your Honor. The counties, Maricopa and Pima counties, recognize that the hearing should take place within 10 days, and understandably, the court did not have time on the calendar before today, and I think that portion is directory to the court. However, the parties still have to adhere to the strict time deadlines, and Mr. Kielski should strictly adhere to the time for service within that 10-day period, and allow the counties at least 5 days to answer before even seeking to set a hearing date.
And my question is, can I give him the 5 days and set the hearing for next Monday under the statutes?
Your Honor, I don't think there's been any good cause showing at this point. I also think further delay is opening up the argument of latches, because this certainly will have a prejudicial effect on counties, and this delay is unreasonable.
How does it explain the prejudicial effect, if you could, on counties? Because in most of these, we're talking about we got to print a ballot, we have to move forward, and it has to go out to the overseas folks first, and we got 3 days left. That's not the case here. So what's the prejudicial effect on the county?
You're exactly right. Public policy in the Donahue case favors stability and finality of elections, and also to instill confidence in the voters in elections. Because we have the next election starting, early voting starting tomorrow. For Maricopa County alone, 1.3 million ballots are going out starting tomorrow. Those ballots are going to start rolling in. Right now, the elections department is in limbo, unsure whether the voting machines can be used. Logic and accuracy testing is going to start today. There are the e-poll books. There are questions even asked about, can the e-poll books be programmed for the next election? So having this election hang over at this time is really causing an impact on the next election.
Okay. Let me just ask, is it the same issue for the other counties, or would they express something different? You're here for a limited appearance, I understand that, but anything, I'm not seeing anything different.
Your Honor, Pinell County, we have nothing else that can add to this also, except for the fact that if you look at the pleadings, we're named only in the caption. There are no factual allegations of any kind that are brought out that we can even respond to.
For Yaphank County, it's the same as.
Same issue,
rules.
named only in the caption.
Your Honor, if I may just briefly, we have.
Okay, and then I'm going to come back to Mr. Kielski, because I'm going to ask you about the good cause question, because that's where we're headed.
Just to confirm, the Secretary's office was formally served yesterday. We have
Okay.
confirmed that.
Thank you, I appreciate it. So, Mr. Kielski, good cause to extend. Well, we're talking about extending through Monday at the latest. So everything needs to be ready to rock and roll on Monday
And that's
because of the
fine.
time
That's
frames we're looking at.
Fine, Judge. As I told the state defendants here, Judge, if the court wants to set the hearing this afternoon, I'm good to go too. I mean, we just want this
The
on.
problem is the statute says
Right.
they get 5 days to answer, and then a hearing can happen. I can't do it on less notice than that.
Right. So let's talk about the good cause, Judge. Again, I think the court mentioned the case Diaz v. Superior Court. There's another matter, Babnew versus Linneman, an 87 case. Untimeliness of hearing on election contest did not preclude trial court from proceeding where the delay was caused by the trial court's failure. So again, in this case, and I put this back on.
No, I understand. Don't worry, I promise not to jump down anyone's throat. We set this hearing today.
Right. And Judge, this is why, in part, there was some confusion. I had originally thought, based on the proposed form of order that I had provided to the court, in which the court had signed, that today's hearing was the hearing, the order to show cause, rather than today's hearing was notice of return hearing for a future order to show cause, which is why I thought we were safe, because we were right on that 10-day mark. And again, then I learned, I think, on Friday or yesterday, that it was actually today was the return hearing, and so that's where we're back to. This issue, and again, I'm not so much interested in pointing fingers or not. I'm more interested in allowing the plaintiffs an opportunity to present their case and to conduct the hearing, so that we can show that this, that the election conduct fell short of what's required by Arizona law.
Let me ask, because, and the one county just brought up that nothing in the complaint relates to a number of these counties. And I understand why you may have named them, but which counties are you saying did something wrong?
Well, we know, and we clearly pointed out that Maricopa County, the very well-known, very public issues came up, and then again, I think the court could take judicial notice of what has been widely reported.
Why don't we go through just Maricopa County?
Right.
Next on the list.
And we believe that there were some issues in Pima County, and we believe that there were issues in Santa Cruz County. And those are the three counties that we specifically focused on whether or not any specific acts were alleged in the complaint. We have provided that information to the state defendants. We previously told them that those are the three counties.
So is it fair to say that the other counties are, what would be in essence a nominal party? They're here because, and any service on them would be not because you're planning on, it would be the three counties that we just talked about.
That is correct. And Judge, let me just briefly address that issue because, again, there was the issue was raised about whether the Secretary of State is a mere ministerial duty, and what the relationship is to that. And Judge, this is unfortunately, just addressing this. There's been a lot of the finger pointing going on where the Secretary of State and counsel for the Secretary of State is saying, well, that's the counties, and the counties are. And again, Judge, the issue is very clear here. The Secretary of State is the chief elections officer. It is her duty, and if she delegates that duty to the counties, pursuant to statute, that doesn't relieve her from the responsibility of having to either to personally comply with that, or to the extent that those duties are delegated, require her to make sure that the counties, those that have those delegated duties, have complied with the statutes. And again, Judge, without getting into a lot of it, the election statutes make very, very clear that the elections manual is and has the force and effect of law, and a violation of the elections manual is in fact a misdemeanor. So again, the Secretary of State, who we've named and who we've served, is the individual who at the end of the day has to make a determination, which I don't believe is ministerial at all. She can't just simply gather all this information from those parties who have done the work that she's responsible for, and say, well, they say it's okay, so I'm not gonna look under the cover and just go ahead and rubber stamp it. That's the issue here, Judge. And again, I would say that going back to the original question, good cause. Good cause is, I believe today was the order to show cause. The court has set this today as a return hearing.
Well, if that was the case, though, wouldn't that completely defeat your case because service didn't happen 5 days ago?
Well,
I guess I'm struggling because if you thought today was the hearing, then everyone needed to be served under the Diaz case at least 5 days ago.
as I said, the Secretary of State received service, personal service by a party or counsel for the party on the same day this matter was filed. As a matter of fact, Judge, and again, this may not go to the issue of service, but this certainly goes to the issue of notice. By the time we got down to the executive tower, they already had the pleas because they were provided them by the clerk of the court electronically before we even got there. So in the time it took us to drive from here to there, they already had it. So again, the issue...
It's still not service. I don't know how it happened, but it's not service.
Right, that's fine. So then the issue becomes, well, under these circumstances, is it a failure of service for the documents to have been personally delivered, especially under this really super tight timeline? Because again, the court is correct. It is calendar days, not court days. So the pleading was filed the complaints were filed on Friday, and they were hand delivered to the Secretary of State that same day. By Monday, Tuesday, discussions were had about waiver of service, and those discussions proved not fruitful. And so again, in terms of lashes, Judge, we did what we could under the rules to try to move this matter forward. And whatever delay there was, it was not a delay on our part. It was, to some extent, it was in the communications that eventually broke down, negotiations about obtaining the waiver of service. But regardless, Judge, I see no reason that...
Let me ask you this, because sure. I struggle with what evidence are you planning to present? Because we're not talking about days and days and weeks of trial.
Oh, no.
What is it that you're talking to present to?
Well, as attached to the complaint, Judge, the court saw or may have seen that there were a number of affidavits attached. A number of the individuals that provided those affidavits will be witnesses. We have a couple of individuals. One individual who was, much like Your Honor, a poll worker and certified to be a troubleshooter, will come in and testify as to in what she observed in Maricopa County on the day of the presidential preference primary and how terrible that process went and how many people came to her again and again whose voter registration had been changed from what they had submitted. And again, that goes directly to two or perhaps three of the key points that we the key allegations that we raised in the complaint. So that is a key witness that we're going to bring in. We're going to bring in other individuals, again, who were the individuals who had experienced some of these very issues, talking about how their voter registration was changed without their knowledge, without their authority, without any input from them at all. We're going to have experts that we propose to bring in that are going to testify as to what they've reviewed as both on the statistical issue regarding the approximately 12% lower voter turnout allegedly in Maricopa County versus what it could have been or should have been.
Let me ask, is
Yes.
there any, I don't see anywhere in there that there's a statistical analysis that suggests the outcome will change. And that's where I struggle, because
Absolutely.
I don't and would never condone someone not being allowed to vote improperly. But at the same time, we're here post-election, and if everyone was equally disenfranchised, which is what I believe you're saying, that there was, it wasn't one particular candidate's people and only those people. It was, a general issue that arose. What is there to suggest the outcome would be different, such that I would go through this and not focus instead where some people are focused, which is on how to make sure this doesn't happen in the future, instead of avoiding certification?
I think the court has zoomed in on exactly the key issue here, Judge. The issue of the outcome, and I believe that was raised by one or more of the state defendants, the issue of the outcome is a distraction, Judge. When one focuses on the outcome and whether or not plaintiffs can show that there would have been a different outcome, or even allege there would have been a different outcome, it shifts, and it's a misdirection, it shifts the focus. Judge, the conduct of elections has to comply with state law. Nowhere in the election contest statutes does it say anything about that the plaintiff has to allege that there would have been a different outcome. As a matter of fact, I would argue, Judge, if outcome is going to be an issue, it is the defendant's burden to show that the outcome would not have changed had the election been conducted as it was required to be conducted under state law and under the elections manual. And to shift that burden to the plaintiff to argue that when there is evidence, again, enough evidence that the court can take judicial notice of what's happened in Maricopa County, but certainly evidence that we're going to be able to bring to court that the conduct of these elections did not comply with state law. Why is it the plaintiff's burden to show that the outcome would have been different rather than the defendant's burden to show that the outcome would not change? It is arguably as I said, largely a distraction. Yes, Judge, it certainly is possible that the outcome might not have changed. But is that the issue in a society such as ours, where we tell the voters, the people at large, you have a voice. You have a voice in your government. You have a voice in helping to select your leaders. And then have a conduct of an election such as this, and then have the defendants in this case go, well, you can't.
So let me ask you this.
Yeah.
Coming back to, are we talking a day with your witnesses?
Yes, Judge.
And for the state's purposes, and the Secretary of State, assuming service was sufficient on that Friday, would be a party, and you filed an answer raising that objection. So I'm not asking you to waive it. What would you proceeding with as far as your evidence? Besides cross-examination?
Certainly cross-examination, Your Honor, depending, and again, we don't yet have a list of who he intends to call or what exhibits he plans to use, and that may change what we need to call in our case, but I wouldn't anticipate calling more than 1 to 2 witnesses.
Okay. And there are 3 counties who potentially are involved in this. Ms. Connie, do you have any idea what you'd be looking at if you were involved in this?
Your Honor, definitely cross-examination time as well as perhaps an hour to put on the county witnesses.
Okay. Kena County, somebody's here on behalf of Kena. You are.
Oh, yes.
So it'd be the same?
Yes.
Okay. Santa Cruz is not present, hasn't even made an appearance, hasn't been served from what I can tell.
No, Judge, we have not served them personally.
And I'm trying to figure out the best way to move forward efficiently and effectively. Counsel, I need you to file your response to the motions by the end of the day tomorrow. You just have to get it done.
That's fine, Judge.
Okay. The reply due by Friday. Does noon work?
Yes.
And, I know that this is other things going on, but Friday work for folks? Possibly there can be a consolidated reply, and I'm fine with that if you folks want to do that.
Thank
I'm
you.
allowing a consolidated response or consolidated reply. The oral motion from the Secretary of State or from the Attorney General would deny. If you want to file something, you can. I don't know how I move forward without service on the counties. So if you're going to try and move forward with this, you're going to have to serve them. You have to serve them today, from what I can tell, if I'm going to start something on Monday.
We'll get it served today, Judge.
It's the only way that I could do it. And I don't know that it's going to be effective at this point because of the late notice. That's what these motions to dismiss are going to be about. So I would suggest folks talk a little bit here after the hearing to make sure how you want to proceed. I'm just looking at the rest of the scheduling. And I guess what for purposes of this, I don't know that good cause has been shown. That's what you're going to have to do in your motion or your response. That's what you're going to be filing. But to make sure that we move forward effectively, we're going to set, and I believe I can do this under the statute. I'd like to hear from counsel now if you think I can. Set it to start on Monday. I can count. I know that today is one day. Then if service happens today on parties, then Wednesday, Thursday, Friday, Saturday, Sunday. Sunday arguably would be the 5th day. Does counsel believe I can't start the hearing on Monday under those circumstances? And I'm happy to hear from folks if counsel thinks that's the case. Ms. Connor?
Your Honor, I think Monday would be fine. I
Okay.
would like to request the court also order the plaintiffs produce a list of witnesses, and also the counties plan on filing a motion in limine to include testimony of opinions by non-expert witnesses.
Sure. And there'll be motions in limine, certainly. Again, I'm not resolving whether or not the service is going to have worked. That's something you folks are going to sort out, but I can't hold back on getting everything else lined up while that briefing is happening. Sir, you're in violation of this court's order. You know it. Yes. I see you holding a camera up.
No, I was given permission by the court. Yeah, he came up right in time.
Okay, I'm sorry.
Yeah.
You're.
I apologize. I mean,
No,
yeah.
that's okay. You're fine. If you talk to Vince,
I did. Yeah, he and I both did.
I did not mean to. I just wanted to make sure
Totally cool.
you understand.
Yeah, I'm fine. I'm fine.
All right, sorry about
I'm gonna
that.
start recording again.
You're welcome to. That's what I told folks, that they had permission from the media relations folks. They were welcome to. I didn't realize that you were one of them. I didn't see it earlier. I would have said something.
Yeah, I wear a T-shirt. I know it's hard to tell.
All right. I had two parents who were teachers.
Your Honor, we're still examining the statute. We have some concern about the language that says it has to be within 5 days. For practical purposes, we don't have a problem with Monday, but we do need to reserve the right to make sure that if there's a statutory bar on it going past Friday, we need to look into that.
Okay.
And if I could just, one point of clarification, we understand the oral motion has been denied. We will file a written motion today. Can that be on the same schedule in terms of response or reply so that we have that before the court?
I think so. I mean, it just all needs to be addressed very quickly. So you'll get it filed and make sure you email it to Mr. Kursky so that he has it. And just, it's the Secretary of State's, and if the governor's going to make the same thing, I suggest that it happen. I don't know whether you're representing the governor on that, but they need to happen quickly.
We will communicate to the governor's office.
Okay.
And Judge, is it the court's preference that does the court get these pleadings quickly enough if it's filed?
Email them to my JA.
Okay.
What happens on e-file is it can be it's not as fast as email.
Okay.
Sometimes it can be a 24-hour delay before they come out.
All right, I'll get the contact information from you, Jay, and we'll be sure to email copies to the
Sure.
chambers. Thank
And
you.
everybody needs to do that. Anything you file send to my JA by email. We'll make sure you have that email. All right. Deborah, what time can we start on Monday? Okay, that's fine. What's in the afternoon? We're gonna have to move it. There's certain things that end up taking priority, so we'll have to move that. And Tuesday is open? I think, from what I heard here, we can be done in a day, but we could have Tuesday morning in case we need it.
Your Honor, if I could just ask, if the counties that are further out, who have to travel that morning, if the hearing starts at 9 o'clock, if the other counties would be excused from appearing until 10 o'clock, if they so choose.
And I would excuse the parties who have been identified as nominal parties. The only parties that and it just seems to me appropriate, that have been identified are Maricopa, Pima, and Santa Cruz. Anyone beyond that, I don't want to have folks needlessly making the trip if they're not going to be required. Now, that doesn't mean you folks can't be here, but I don't want to have you making a trip unnecessarily. And you folks can decide whether one person can make the oral argument with regard to the motion to dismiss, or whether you folks want to each speak. And I'm happy to work on the telephonic on that because I do understand that, but I also understand some folks may want to come down. So I would waive the presence of all the counties except Maricopa, Pima, and Santa Cruz for purposes of Monday's hearing. Mr. Kielski, do you have any problem with that, given what you've identified here?
I do not, Judge.
Okay. Before I do it, I want to make sure that you were heard. All right, so that's what I'll do for purposes of that. And so that folks know in the audience, you can't raise your hand, I can't answer questions. Mr. Kielski can talk with you afterwards. I'm not trying to be rude, I just can't. All right. Schedule, can you exchange your witnesses at the same time that you do the other things? You've got a lot to do over the next day.
Yes, Judge.
Okay. And county, can you get your county and state, the three counties we're looking at, Pima, Maricopa, and Santa Cruz, you can get those together?
Yes, Your Honor.
Okay, Santa Cruz has not been served yet, but I'm assuming that they can get on board fairly quickly. Do we expect Pima County to be here separately? Do you know, Ms. Collins?
I believe they will be here separately. Dan Jerkowitz.
And Santa Cruz likely would be the same under those circumstances?
I believe so.
Okay. All right. So let me ask, just given what we've set up here, anything else we need to do here today? Mr. Kielski, from your perspective?
No, Judge, I think it's pretty clear. I'll be responding to the various pleadings. I will be responding to the motion that I believe is going to be filed shortly by the Attorney General, and I will provide a list of proposed witnesses and potential exhibits to the state defendants, and I will try to do that. I just want to be sure that I got everybody's email address before we leave here today, just to be sure that we'll do it.
If you folks make a list, we'll make a copy for you. So make a list, we'll make copies so that you have it, and that way my JA has it as well. Probably the best way to go.
Thank you, Judge.
How about let me start with the state. Anything?
Your Honor, just preserving our objection so that we can review the 5 days good cause question. And then, again, just to clarify, I know there are a number of motions, but that the motion for inspection is still live in the
Can you
secretary.
do that before the end of the day, and if there's a motion, so we can deal with it?
The motion for inspection is already pending, though. We filed that last week. It was,
Right.
so that was the day, and we will file the Attorney General's motion to dismiss today.
But I'm talking about the motion, if there's any objection on the 5-day issue, can we get that in
Yes,
before
sure.
the end of the day? And
Yes,
that way
sure.
folks know what the issue is. I understand, I can't say I have researched that completely. And and if we're, quite candidly, if Monday doesn't work, then there's no day that will, because those counties haven't been served. And so it's either Monday works, or I think there's nothing I can do as far as an evidentiary hearing. So look into it. All right. Anything else for the other folks?
Judge, just to
Yes.
clarify, Monday will begin with arguments on the motion to dismiss.
Likely. That's kind of how I see it happening, but if folks need to be ready for the evidentiary hearing, because I've got to keep the train moving. I can't say, okay, we'll do this and then we'll see, and then we'll set an evidentiary hearing. The train just has to keep moving all the way down the track, and some things are just moving at the same time. Parallel tracks.
Thank you.
Okay.
Judge, another issue, because of the intense public interest, could we ask the court to locate a courtroom that has more space for audience, as well as, again, potentially we'll have quite a few witnesses that will be testifying as well?
Well, and I don't know that I can, but we can certainly look at it. But one thing we can always do is see if we can also arrange an alternative viewing location where we can have screens and folks can observe it live through the FTR system I was talking about, though they won't be in the same courtroom.
Thank you, Judge.
We'll see what can be done on that. I'm just trying to think, if you file that motion today, if there's anything with regard to timing, you'll need to reply to that as well, or respond to that tomorrow
Absolutely.
and Friday. We're just all on the same track. Everything happens by Friday. Go ahead.
I'm sorry, were you saying the motion for the counties to file? I'm also going to file a motion in limine.
Right.
We'll file that today.
Yeah, I just want to keep them because everything needs to happen so it can all be resolved, folks can read it, and we can move forward. All right. One last thing. Folks have been calling my court, and I have no problems with folks calling. The scheduling, how evidence is handled, how Skype is handled, things like that, are things that Mr. Kielski is aware of. What I do is ask you to contact him about that. We are, and I'll just explain to folks, we have the electronics. You folks are actually welcome to come down if you want to see how they work and practice with them a little bit. They're fairly straightforward. There's nothing exceptional. It's an Elmo. It shoots up on that screen. The witness will have whatever's on the screen in front of them on a smaller screen. We also have the ability to hook computers up if you want to do PowerPoints or things like that. Skype is available, but you need to work with our computer staff to set that up. And if you're going to be using Skype in any way, you need to contact us right away and let us get you in touch with the computer people, because they need to set it up to run through our system if you're going to try and have Skype run through our system. There are security measures that need to be put in place. So if you're going to try and use Skype, you need to make that decision probably by tomorrow at the latest. I would say the end of today, so that you can, and you're going to have to come down here and work with our computer people to have it set up, because they actually have to set up a very secure system because it's run through our system at that point, our internet system. So it just can't be done randomly. So if there's any Skype, but again, folks, I understand that you're all interested, but the attorneys are responsible for handling who's going to testify, when, how to handle those things, how to handle the exhibits. That's the process we go through. So Mr. Kielski is your point of contact on that. If anyone's here on the state side, the attorney that's representing you or your agency is your point of contact for that. I think that takes care of what we need to do today. We'll get these briefings done. We'll look at the oral argument at 9 o'clock, and then start the evidentiary hearing to the extent there is one by 9:30 at the latest. All of this is contingent on all of the counties being served before close of business today. I don't know how it can't happen any other way, because Monday is the first day a hearing could happen, and that assumes they're served today. All right. And let me just, I think I got this, Ms. Connor, or Secretary of State, your position is that if all counties aren't served, then the case can't be served. Is that accurate?
That's accurate.
Okay. Is that accurate?
Yes, sir.
And so that is their position, and understand that that's part of why I'm saying what I'm saying. I'm not resolving that issue, but if their position prevails and all the counties aren't certified today, the hearing can't happen on Monday. All right, I'm going to go ahead and step off the bench. Thank you, folks, and we'll see you on Monday.